I believe I had reasonable suspicion.
Okay. And after you obtained consent from Mr. Smith to search the vehicle, and you ran the K9, at that point, did you believe you had probable cause to search the vehicle?
Yes, ma'am. Once the canine alerted on the vehicle, absolutely.
Okay. At that point, did you have probable cause to search Miss Morris's purse, given that it was in the vehicle that a positive alert was made on?
Yes, ma'am.
Your Honor, we pass the witness.
Mr. Murray, leader, any questions of Officer Chandler?
Yes, Your Honor. May I share my screen, Judge?
Yeah, what are you going to share?
It's going to be the State's Exhibit 2, the dash cam.
Yes, sir.
Officer Chandler, can you see this video that's on screen currently?
Yes, sir. It's our fire station.
Okay. Let me just introduce myself real quickly. I don't think we've met before, have we?
No, sir.
My name is Shrav Murley there. I represent Ms. Morris for a criminal case. All right, I'm going to play this dash cam video starting from the beginning, which is the identical copy of the State's Exhibit 2 of your dash cam. If there's anything that's different, please just let me know. The complete video that I have from the DA's office is 51 minutes and 5 seconds long. I'm going to start playing from the beginning.
And Mr. Murray, leader, do you intend to play the whole video?
No, Judge, just the first few minutes.
Okay, thank you.
All right, Officer Chandler, I'm going to stop it there at 24 seconds. At this point, you turn onto a road and you see Mr. Smith's black Chevy vehicle in front of you. Is that right?
That's correct.
We'll continue. All right, at this point, I'm going to stop it at 40 seconds. I would say maybe like 15 feet away from his vehicle. Is that an approximation?
Yes, sir.
At this point, were you able to see his back license plate?
I can see the back license plate. Yes.
Was it legible and visible?
It's visible, but not legible.
Okay, I'm going to continue playing. So at approximately 1 minute, I've stopped it there. You activate your overhead lights. Is that right?
That's correct.
And he's indicating that he's going to pull off and turn into just for the stop. Is that right?
That's correct.
Okay, I'm going to continue. Okay, I've stopped the video at 1 minute and 13 seconds, and Mr. Smith's vehicle has come to a full stop, and so have you. Are you able to read the back license plate at this time?
I can read the back of the license plate. However, the E or the F is not legible.
So you were saying that you're unsure if it's an E or F at this distance of approximately 6 or 7 feet?
With this video, yes.
Okay. And when you were behind Mr. Smith, you still could not see whether or not it was an E or an F at this distance?
At this distance, I could tell that it was obscured with rhino liner.
Okay. Are you able to make out at this point today what the license plate says? And
I
if so,
can right now.
that out?
Yes.
Can you please read that license plate number out?
Henry William, it's going to be E or an F. I believe it's 9809.
All right. I'm going to stop sharing the screen at this point, Judge. All right, Officer Chandler, what is the transportation code violation that you observed? And specifically, if you know any like section number yourself.
It's going to be the license plate that's obscured.
But you don't know the specific.
I don't know the exact traffic code.
Okay. And do you know how much of the license plate has to be obscured before it becomes a violation?
If you can't read it, it's not legal.
At what distance does it have to be visible and legible? You know?
Well, at nighttime, it's within 50 foot as far as license plate lights go. If I can't read it, I can't read it. It's plain and simple.
Okay. After we just watched the body cam in State's Exhibit 1 when Ms. Heisel was questioning you. Can you tell me the names of the officers that were on scene?
The officer is TJ Foster.
And was there another officer there as well?
I believe Christian Barajas came up later.
Okay. Is it safe to say at that point, once the vehicle was stopped, neither Mr. Smith or Ms. Morris were free to leave?
Yes, they were under temporary detention for a traffic stop.
Okay. About 10 minutes into the video, I think you had arrested Mr. Smith after.
Go ahead, Mr. Murley. I've muted Ms. Morris.
Okay, thank you, Judge. And I was going to ask for you to do that same because I'm not going to ask for her to be a witness. I'll just repeat the question, Officer Chandler. At about 10 minutes in, you had arrested Mr. Smith for a warrant after you ran his information. Do you know what that warrant was for?
I believe it was for theft.
Did you have any indication of any property of that theft in that vehicle at that time?
I'm going to object to relevance.
Judge, it goes towards whether or not there is sufficient facts to prolong the stop. And I want to probe whether or not Officer Chandler knows about that.
I'm going to sustain the objection as to relevance.
All right. You mentioned that there was a theft of property warrant. Is that correct?
That's correct.
All right. At that point, you had arrested Mr. Smith and he was put into your police vehicle, right?
Yes.
And you had asked him for consent to search his vehicle. Why was that?
I had reasonable suspicion that there may be something in the vehicle based on his body behavior.
Did you have prior dealings with him?
I have had prior dealings with him, yes.
And what did you suspect to be in that vehicle by asking him consent?
Stolen property in one thing, also narcotics, because he's at a residence that was later served with a warrant for narcotic activity.
When you say that there was narcotics in the vehicle, was there indication from your interactions with him that day, in that first 10 minutes of the stop, that indicated that there was any narcotics in the vehicle?
He did not tell me that there was any narcotics in the vehicle, but based on his nervousness, sweating, all that, I believe there was narcotics in the vehicle. all the while he was at a house that was known for distributing narcotics.
So you're saying that because of his nervousness or sweating, you suspected there to be narcotics in the vehicle?
A possibility, yes.
At that point, after you had arrested Mr. Smith and Miss Morris was still standing by that tree, why wasn't she free to leave?
Because I was conducting an open air sniff around the vehicle with the canine.
Was there anything that prolonged her detention in order for her to stay there longer?
To further investigation of the traffic stop, yes.
What facts do you have to say that you could prolong her detention? And be specific, please.
Well, the fact that she did not want to identify. And if you look on the video, she's trying to exit the vehicle as fast before I even get out of the vehicle. She's trying to get away from the traffic stop. That's also an indicator that somebody's trying to hide something.
So the fact that she did not want to identify or that she tries to exit the vehicle, those are facts where you prolonged her detention in order to search the entire vehicle?
I believe that my detention was reasonable.
So I'm going to ask that question again. So the two reasons that you prolonged her detention was because she did not want to identify and she tried to exit the vehicle when you were first stopping her. Is that right?
Yes, she's trying to get away from something with officers.
Is there something inherently wrong with a passenger of the vehicle not wanting to identify themselves?
No, sir. It does come off suspicious. I have had numerous people that have not identified.
Okay, but it's not indicative of any illegal activity. Is that right?
Yes, it is. It is.
What illegal activity is it indicative of?
Well, it's reasonable suspicion when somebody is trying not to identify to law enforcement. Most people that are doing the right thing are going to identify correct. So when somebody is sitting there not wanting to identify, such as herself, not making eye contact and being very nervous and fidgety with her belongings, she's trying to hide something.
Okay, you mentioned a couple more things about that. I'll follow up with that, but you specifically said that there's nothing wrong with a passenger not wanting to identify themselves, correct?
Yes.
Okay. After you just mentioned, sorry, I'll just go back. You just mentioned that she tried to not make eye contact and was being fidgety with her belongings. Are you saying that those are also reasons for you to try to prolong the stop?
Reasonable suspicion, yes.
Would you agree with me that after Michael Smith's arrest, there was no probable cause to keep Miss Morris at the scene any longer, correct?
No. After Mr. Smith's arrest, probable cause was established with the canine.
So before the canine search. So before the canine search and after Mr. Smith's arrest, all right? Right after you arrest him, did you have any probable cause to keep Miss Morris on the scene?
No.
Okay. And you're saying that the reason you prolonged the stop for Miss Morris is because she did not want to identify herself. She tried to initially exit the vehicle. She was not making eye contact and was being fidgety with her belongings. Is that right?
Yes.
Did you ask Miss Morris for consent to search her purse?
I believe I did, yes.
Did she give consent to search her purse?
She did not.
Um, I want to talk about the canine search. Approximately how many times have you deployed your canine since he was certified?
I'm sorry, say that last part again.
Approximately how many times have you deployed your canine since he was certified?
I do not have that information in front of me.
Do you have an approximation at all?
No, sir, because I train constantly. I could not give you an approximate number on deployments.
Okay. Have you heard of the term false positive?
Yes, sir. That's no such thing as a false positive.
What does that term mean?
In other words, you're trying to say that the canine was cued to a positive alert.
Is that your understanding what a false positive is?
Yes, sir.
Okay. I'll just explain the term false positive as I understand it.
Okay.
False positive means that there's an alert for drugs and there are not actually any drugs. Have you ever heard that term before or that definition before?
Yes, sir.
So it's basically when the dog alerts and you don't find anything. Do you understand?
Yes, sir.
Have you ever had that instance with canine Figo?
No, sir.
So every single time that canine Figo has alerted, you're saying that you found drugs or some kind of contraband?
I'll have to look at the records, but every time that he was deployed, there was paraphernalia or residue odor.
So canine Figo has 100% success rate. Is that what you're saying?
Like I said, I have to look at the records. I can't tell you that.
Okay, so you don't know?
Now, was there an arrest every time that he was deployed? No.
No, that's not the question. I was just asking if canine Figo has found contraband or drugs or anything 100% of the time that he was deployed and alerted.
No, sir.
So no, he didn't find drugs 100% of the time, or no?
There was not. Okay. So the question that you're asking me, you're trying to make me say that my dog is not, canine Figo is not 100%. If you look at the federal laws, or I'm sorry, the federal case laws on the accuracy of the canine, you'll understand.
I'm going to repeat my question, okay? Has there been an instance? All right, let me put it a different way because I think we're coming up to impasse. Has there been an instance when canine Figo was deployed and he alerted and you didn't find any drugs or contraband?
Yes, sir.
So there have been instances of that, right?
Yes, sir.
And do you know how many instances of that actually happened?
No, sir.
Was it a handful of times?
I can't give you an
I'm gonna
answer.
object to asked and answered. He says he doesn't know an exact number.
I'll overrule the objection.
I'm sorry, I didn't hear your answer, Officer Chandler.
I said I cannot give you a number.
Okay. Officer Chandler, after the canine alerted to drugs in the vehicle, at that point, did you believe that you had probable cause to search my client's purse?
Yes.
Okay. And that was because of the alert that canine Figo specifically gave?
Yes, sir.
Can I ask why you deployed canine Figo after Mr. Smith already consented to the search?
Because her belongings were also in the vehicle. I cannot search her belongings if she denies consent, even though he gives consent to his vehicle.
Okay. All right. Thank you, Officer Chandler. I'll pass the witness, Judge.
Ms. Heisel, any additional questions for Officer Chandler?
Yes, Your Honor. Officer Chandler, in the video, we see canine Figo jump up on the window and then sit and look at you. Is that how he alerts?
Yes, ma'am. That's one of his alerts. Yes, ma'am.
And did he alert on both the driver's side and the passenger side of that vehicle?
Yes, ma'am. On the passenger side, you'll see him actually put his nose in the door, between the cab and the door. Yes, ma'am.
Your Honor, I pass the witness.
Mr. Murray, no further questions. Is there any objection to Officer Chandler being finally excused for today's hearing?
No,
All right, Officer Chandler, you're free to go. Thank you, sir.
Thank you.
and Judge, may I have just a brief recess to go get him unset up?
Yes, ma'am.
Thank you, Judge.
How long do you need?
3 or 4 minutes.
Okay, I may go ahead and see if Mr. D'Angelo or my other pleas are ready. So we'll take a break in this hearing. Is there anyone present in the jail court at this time? Oh, there you are. Is James Corey Ferguson ready? If you can bring him up. Yes. We'll go ahead and conduct his plea while we're on recess in the other hearing.
Thank you, Judge.
Right up here, sir.
All right, Mr. Ferguson, I need you to raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, you are James Corey Ferguson, is that correct?
Yes, sir.
And Mr. Ferguson, get back here. You appeared before this court on June 2nd of 2020, and you pled guilty to the second-degree felony offense of aggravated assault with a deadly weapon. Court heard the evidence, found that there was enough evidence to convict you of that offense, and the court convicted you and sentenced you to 10 years confinement in the Texas Department of Criminal Justice, but the court suspended that sentence and placed you on community supervision for 3 years.
Judge, just to clarify, that was a modification. The original sentence was before then, Judge.
Okay.
Your Honor, that's correct. He was placed on deferred supervision for a period. We had an MTA. We adjudicated him and placed him back on probation. And that catches us up to where we are today.
Correct.
But it was on that date, and he did plead guilty, and the court did convict him.
Yes, that's the day that he was convicted and reassessed as a different term of supervision.
But it was 10 years in prison, suspended for 3 years probation.
Correct.
All right, and so during that term of your community supervision, Mr. Ferguson, the state filed a motion to revoke your community supervision, and they alleged in 5 separate counts ways that you violated. Have you had an opportunity to review that motion with your attorney, Mr. Carlo D'Angelo?
Yes, sir, I have.
You feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the proposed plea agreement today that you do not understand?
No, sir, it's pretty simple. You gave me a chance and I dropped the ball.
Okay, and is it your understanding that today's agreement would be that you're going to be pleading true to those counts, and in exchange, the state's going to be recommending that your punishment be 6 years confinement in TDC with you paying the state's going to abandon count 1 of the motion to revoke, and then they're also going to recommend that you pay your financial obligations and receive 74 days credit towards your sentence. Is that your understanding of the plea agreement today? Yes.
Yes, sir.
Okay. And throughout the paperwork, if your signature appears, are you telling me that that is your true and correct signature on the paperwork, and that you've only signed that paperwork once you have read it and discussed it with your attorney and that you understand it?
Yes, sir.
All right, Mr. D'Angelo, does your client waive the formal reading of the state's motion to revoke?
Yes, Your Honor, he's been provided a copy. He has reviewed it and he understands the nature of the allegations.
And you believe him to be competent today to enter into this plea agreement?
Yes, sir, Your Honor.
All right, and the court notes state that you are abandoning count 1 of the motion to revoke. Is that true?
Yes, Your Honor, that was a new offense. It's also not in the plea paperwork, but a term of the agreement that our office would reject that new offense, which had a DA number here in our office, but it had not yet been filed.
All right, thank you, Ms. Heisel. All right, Mr. Ferguson, then at this time, the court's going to ask you, how do you plead to counts 2, 3, 4, and 5 as alleged in that motion to revoke? Are those counts true or not true?
They are true.
All right, and Mr. Ferguson, are you telling me that those are true because in fact they are true and for no other reason?
Yes, sir.
And has anyone threatened you or forced you or pressured you to plead true to any of these allegations?
No.
All right, the court will accept the defendant's plea of true at this time. Mr. D'Angelo, is there any objection to the admission of the defendant's waiver of rights and plea of true as states?
Subject to the, I'm sorry, Judge, subject to the terms of our plea bargain agreement in this matter, no objection.
All right, court admits State's Exhibit A, takes judicial notice of Mr. Ferguson's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
Anything further from the defense, Mr. D'Angelo?
No, Your Honor, we respectfully ask the court follow the recommendation. Thank you.
All right, based on the evidence presented to the court will find that Mr. Ferguson has in fact violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. Court hereby revokes Mr. Ferguson's community supervision, assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division upon the finding that he has violated the terms and conditions of his community supervision. Court also orders that Mr. Ferguson pay the balance of his financial obligations. Court finds specifically that Mr. Ferguson has violated terms and conditions of his community supervision as outlined in state's motion counts 2 through 5. Court hereby awards Mr. Ferguson 74 days credit towards his sentence in this cause for time that he has spent in jail. Mr. Ferguson, whenever you get out of TDC, I need you to contact the Van Zandt County Courthouse so you can make arrangements to discharge the financial obligations that you owe.
Yes, sir. Can I pay that now?
Yes, sir. You can pay that at any time. If you have family members that are willing to pay that now, or you can make arrangements to pay it yourself or through your counsel. Yes, sir. And actually the county would appreciate that very much if you could.
Yes, sir.
If you're not able to, then you can, contact the courthouse and we can put you on a payment plan and you can begin discharging that now or when you're released. Okay. So Mr. Ferguson, you're committed to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of this sentence. Good luck to you, sir.
Mr. Ferguson, step over here, please.
Thank you, Your Honor.
You're welcome. Thank you, Mr. D'Angelo.
Have a good day, sir.
You too.
Judge Martin,
Yes, ma'am.
I don't know what else you have on the docket this morning, but we do have Mr. Martin Rueda here with his client. There was an issue that popped up at the last minute about an interpreter that Ms. Taberham, if she's there with you, she might be able to fill you in.
She has already. She has already. So Mr. Rueda, I see you back there. So Mr. Rueda, if you have already, it's my understanding that you're bilingual. Is that correct?
I'm sorry, Judge?
Is it my understanding that you're bilingual?
Yeah, I am, Judge.
Okay. And so have you already explained the paperwork to your client?
I have. I've gone over every document. He's signed every document. He understands
Okay.
everything that he signed.
So because the court requires a certified translator to conduct a plea, we've made arrangements for a translator to appear via Zoom at 2 p.m.
Okay.
So if the jail can assist us in having Mr. Leha back present in the jail court at 2 p.m., then you could appear via your office via Zoom if you want to go back.
Yes, Judge, that's fine.
And you're welcome to stay in town. And I know that's quite some time from now, but you're welcome to stay if you want to conduct the plea with your client there in the jail court. You can do that. Otherwise, we'll have our interpreter Zoom in and we'll conduct the plea at that time. If the paperwork's already signed, then we don't need your presence any longer physically.
Okay, Judge. Question, the same meeting ID will remain the same for the 2 o'clock hearing?
That's correct. Yes, sir.
Okay. Thank you, Judge. I appreciate it.
All right. So we'll see you at 2 p.m.
All right. Maybe excused.
Yes, sir. Thank you. Appreciate your help this morning.
Thank you. Thank you.
Yes, sir. Be careful, sir. Your Honor,
Deputy.
yes, sir.
I was going to say, will it be any kind of issue to have you or someone else have at 2 p.m.?
We got it.
All right. Thank you. I appreciate that.
Yes, sir. Is there anything else I can do for you, sir, this morning?
I don't believe so.
Judge,
Okay, then if you don't-
we released her. Mr. Ashmore has let me know that Mr. Norris said at 1:30 does intend to take our plea agreement, which would result in him accepting a sentence of TDC time. So will the jail be available at 1:30? I mean, I know there will be somebody at the jail to receive him, but would it be possible for him to conduct that plea from the jail court at 1:30?
I don't see why not. You said for James Norris?
Yes.
He is here in custody, correct?
Oh,
That's-
yeah, he's already there. Yeah, so he'll need to be brought up. And I assume Mr. Ashmore will be bringing that paperwork out to go over it with him before that time.
Don't confuse me, Miss Heisel. It's already been that kind of morning.
I know things have changed about 4 times on each of these cases, so.
I was
Yes,
going to
ma'am.
say, I believe Mr. Manning has a client at 1:30 who's also incarcerated. Is that correct?
Yes, sir.
So that we will already be here at 1:30 and at 2 and at 3. Is that
Not at 3 anymore.
at 3?
That's right.
She's in Henderson. She's in Henderson County, so you don't have to worry about that one.
Yeah, she won't be appearing via Zoom, but we will not need you, Deputy, at 3, but we will have Ms. Ozuna on Zoom.
Okay, thank you, Judge.
All right.
I'm signing out, folks. Thank you.
Yeah, she's signing out before we say something else.
Before we add anything else,
All right, let me see if I can bring your client back in. I put her back in the waiting room during the recess. All right, Ms. Heisel, are you ready to proceed again on Ms. Morris's case?
I am, Your Honor.
All right, we'll go back on the record, CR 2220, State versus Tasha Jean Morris. When before the recess, the court received the testimony of Officer Mackenzie Chandler, and he has been excused. Do you have any additional witnesses or evidence at this time, Ms. Heisel?
No, Your Honor, the state would rest.
All right, Mr. Murray Leader.
We have no witnesses, Judge. We rest as well.
All right, just reserved for close.
That's right, Judge.
All right. And it was your motion, Mr. Murray Leader. And so I'll allow you to close first.
Thank you, Your Honor. May it please the court, counsel for the state. Judge, I'd like to point out 2 things. Number one, on the stop, Officer Chandler said that he couldn't give a specific transportation code. That transportation code number is 504.945, and it reads that it's a violation of the transportation code if the license plate has a coating, covering, protective substance, or other material that A, distorts angular visibility or detectability, B, alters or obscures 1/2 or more of the name of the state in which the vehicle is registered, or C, alters or obscures the letters or numbers of the license plate number or the color of the plate. From the dash cam video, I was able to view and read the license plate from when it was stopped, and this transportation code doesn't give a specific distance at which it needs to be legible. So I'd ask the court to review that footage again to see if the court finds that to be altered or obscured, which I don't find it to be. On the issue of the search, Your Honor, so the Officer Chandler is right. After he obtained consent to search from Michael Smith, he couldn't search Ms. Morris's belongings and would need independent probable cause to search her belongings. And absent reasonable suspicion, police cannot extend the stop for a passenger to conduct a dog sniff that violates the Constitution, shield against unreasonable search and seizures. That's in Rodriguez versus State. That's not quoted in my motion, but it's 135 Supreme Court 1609. And furthermore, Officer Chandler said that he prolonged the detention for Ms. Morris for these following reasons as he believed to be reasonable suspicion. Number one, that she did not want to identify herself. Number two, that she tried to exit the vehicle when he initially stopped the vehicle. Number three, that she was not making eye contact. And number four, that she was fidgety with her belongings. So I'll take each one of those one by one. The not wanting to identify When he stopped Michael Smith and walked over to the driver's side window and asked Ms. Morris what her name is, she asks him, you know, do I need to give it? And he said, no, you don't need to give it. There's nothing wrong with that. And during our hearing itself, he also said that there's nothing wrong with that. So I would posit that that alone is not reasonable suspicion. He said that she tried to exit the vehicle. However, when he walked over to the driver's side window, you see that she's not trying to exit the vehicle. She opened the door ajar. That's not the same as trying to exit the vehicle. You'll see from the dash cam video, as well as the body cam video, she doesn't set any part of herself outside of the vehicle. She doesn't put her foot outside the vehicle. She makes no gesture to leave the vehicle. In fact, it's left ajar until she's told to step out of the vehicle. So she didn't try to run from the vehicle or exit the vehicle. She just opened the door of the vehicle. Number three, he said that she was not making eye contact. Not making eye contact is not indicative of any kind of illegal wrongdoing, nor would I think the state would argue about that. And being fidgety with her belongings. He said that she was being fidgety with her belongings. Again, that is not sufficient enough for reasonable suspicion on its own. And these four things alone do not have any kind of nexus between reasonable suspicion and illegal activity. For these four reasons, he stated that he prolonged her stop. And I think that that would be a call by the court, you know, on whether that would satisfy the law of reasonable suspicion. And, you know, I would argue that it does not. And for those reasons, Judge, we would ask the court to grant the motion to suppress and after the court reviews the video. Thank you.
Thank you, Mr. Murray. Ms. Hillary, would you like, I'm sorry, Ms. Hillary. Ms. Heisel, would you like to respond?
Yes, Your Honor. I'm going to begin with transportation code because that's where Mr. Murray began. Judge, again, like he said, this is going to be a question for the court because I'm watching the video, which I understand is not as clear as in person, but I also was unable to tell whether that was an F or an E. So from my perspective, viewing the evidence, I agree with Officer Chandler, and I believe his testimony that in person, he was unable to determine whether that was an E or an F. And if it alters or obscures the letters such as that they're unreadable, then that is a valid stop, Your Honor. As for the reasonable suspicion to extend the stop, Mr. Murray points out all of these things individually, but the court knows, and it's commonly established that it's a totality of the circumstances determination. It's not death by 1,000 cuts, Your Honor. Officer Chandler testified at length that all of these things that Mr. Murray pointed out individually, not wanting to give your name, trying to remove yourself from the vehicle, not making eye contact, all of these things are commonly deployed by people who have some reason to try to avoid contact with police, being that they are engaged in some kind of illegal conduct. And as a totality, Your Honor, we believe that there's more than enough reasonable suspicion for him to have extended the stop. There's also case law on extension of the stop for a drug dog sniff that says you can't extend it what is beyond what is reasonable. And in that case law, I believe they say 30 or 40 minutes was unreasonable, but here the drug dog is already on scene in the back of his patrol unit. He extends the stop for maybe an additional 2 to 3 minutes, Your Honor. That is, in my mind, and I would implore the court that is a reasonable extension of the stop to establish probable cause. That probable cause was established by multiple hits on the vehicle by the drug dog, and then Ms. Morris's own admissions that there was something in her purse, which led to the search and the eventual discovery of the methamphetamine. The state would propose that all of this was completely legal, and we would ask you to deny the motion to suppress, Your Honor.
Thank you, Ms. Heisel. Mr. Murray, do you want to respond at all?
Thank you, Judge. I'll just respond to the totality argument. You know, I'm not arguing that the court can take into account multitude of factors in determining whether or not it's reasonable suspicion. I just wanted to point out that each one of those factors alone is innocuous behavior. It is not illegal behavior, and it's not indicative of anything that would indicate any kind of illegal behavior. And even taken together, as I pointed out earlier, there's nothing to indicate from those four factors that he described that would amount to reasonable suspicion. I have found no case law that says that opening the door or not wanting to identify yourself or being fidgety or this not making eye contact are any kind of indications when taken together amounts to reasonable suspicion. Now, if the state has something that shows otherwise, I would be glad to yield that point, but I did not find any case law to suggest that. And he mentions all of these factors on video itself. So I believe even taken together, they're innocuous and does not amount to reasonable suspicion. Thank you, Judge.
Thank you, Mr. Merleader. All right, I believe what we should do here is let's go ahead and set this case for docket call. So we have another setting, and we'll set it for docket call, and we'll also set it for status on the court's ruling on the motion to suppress to give me time to review the videos in totality and in person rather than in Zoom. Mr. Merleader, do you know when you're due back here on any other cases, say either March 23rd or 25th? You're on mute, sir.
The next time I'll be there, Judge, is on March 9th docket call, but I can be back whenever the court would like, in March 23rd or 25th if it requires those dates.
Let me ask before I set it for the 9th. You've obviously received the video. You feel like you've received all discovery, and have you received a plea offer in this case?
Yes. Ms. Morris has rejected the plea offer, but if the state wants to extend any kind of plea deadline, I can. Ms. Heisel and I spoke yesterday briefly about another potential plea offer, but I have not been able to counsel my client on that. And if the state wants to extend that deadline until the next court date, I can ask that. But otherwise, we've rejected every plea offer that the state has had.
And Judge, if I could briefly address that. I sent Mr. Merleader an email, I believe it was maybe week before last, because last week was a black hole, that the state, if we proceeded with this motion, that the state would be pulling that offer. Also, Mr. Merleader and I spoke yesterday, and I told him that if we proceeded with the hearing today, that the offer we discussed yesterday would also be pulled. So the state may make an additional plea offer, but it would be for more than what Ms. Morris has previously rejected.
Okay. So what I'll do is I will set this for docket call and status on the court's ruling on motion to suppress on March 9th at 9 a.m. And that's to coordinate with your schedule, Mr. Merleader. If you want more time to speak with your client between now and then, I can do that, but I'm just really trying to coordinate with your schedule, Mr. Merleader. What's easy for you?
That's fine, Judge. If the court feels that it has enough time to do that, we can make an announcement by then.
Yes, I believe I will. If I can get those videos over today, perhaps, then I feel like there's a good chance this afternoon I can go ahead and watch those, and the court should have plenty of time. So we'll set for docket call on March 9th, and then also status on the court's ruling on the motion to suppress. It'll be my intention to have the ruling done well in advance of the 9th, so that either one of you will know what your position is going into that docket call.
Thank you, Judge. And I'll get Ms. Edwards to copy these for you today and make sure they get over today.
Okay. All right. So Ms. Morris, you're due back before the court via Zoom on March 9th at 9 a.m. Just raise your hand if you understand. Okay. The record will reflect that she's raising her hand. Stay in contact with your bondsman and your attorney, Mr. Merleader. All right. And you're free to go, Ms. Morris.
And And Judge, that's all I have as well. May I be excused?
Yes, thank you, Mr. Murray. Appreciate you today. Thanks for your patience while I work through some of these other cases.
Thank you, Your Honor. I appreciate it. This was a suppression hearing by Zoom. It was new, weird territory, so
Different, yes.
different. That's right.
Not better, just different.
But we survived.
We did survive. We're not languishing, so. All right, well, I appreciate y'all's patience in working with me today on this stuff. And State, I guess I'll see you back in about an hour and a half.
Sounds good. Thank you, Judge.
All right, thank you.